Hi everyone, my name is Kate Halifax and I am part of the real estate dispute resolution team at Harrison Clark Whitby's. This is the first video in a three-part mini-series, and we're just discussing a number of different topics really, because we're 1 year on from COVID, a bit more than that now. So we're just discussing the impact that's had from a number of different perspectives. So in this first video, we are looking at landlords' remedies, or one might like to say lack thereof, as a result of COVID. To talk about this issue, I am joined by Andrew Walker. Andrew heads up the real estate dispute resolution team at the firm. And from a litigation perspective, Andrew and I have very much been living and breathing this issue over the past year. The main difference for us has been that the usual landlord's remedies for non-payment of sums due under the lease were essentially ripped out from under us or almost overnight. So kind of the usual advice we'd give to clients and kind of usual avenues we would go down and seek to explore were no more. So it was quite a dramatic change. And in terms of where we are now, I think, Andrew, I'll hand over to you. And if you can just give us a run through of what landlords can and can't do at the moment.
Yeah, thanks, Kate. I mean, the usual remedies for a tenant default were forfeiture, if the landlord wants to bring the lease to an end, stat demands, winding up petitions for arrears of rent, use of the CRAS scheme to seize tenants' goods. But the moratorium, which Kate's mentioned, until 30th of June, and it's been extended a number of times, has now in effect limited the options available to a landlord. He can still sue for arrears of rent, and the tenants are still liable for rent. Some tenants, and we found this, Kate, haven't we? Some tenants think that because of the moratorium, it means they can avoid, they don't have to pay rent, they don't have a liability for rent, but that's not true. The landlord can still sue for the arrears of rent and could get a judgment. But where the moratorium would bite is if the landlord then wanted to use a stat demand or winding up petition for that, it would not be effective. But the commencement of proceedings will put a pressure on the tenant, and the tenant will incur costs, and that might well encourage them to pay. The other thing a landlord can look at, probably before any formal process, would be to look for any guarantors to the lease and what's their worth. A firm letter, either from the landlord or from us on behalf of the landlord, reminding the guarantor of their liability, that could produce payment. And you could sue the guarantors then and enforce judgment if the guarantors don't pay. Rent deposits, that's another thing that should be checked. If there's a rent deposit, query, draw on it now. And often rent deposit agreements require the tenant to top up the rent deposit. And if the tenant fails to do that, again, you could take court proceedings to require them to do that. I think that's probably the other most obvious points. Does anything else occurs to you, Kate?
No, I think you've covered them off really well there. But one of the key points is that yes, we can look at court proceedings, but the landlord has to stump up the issue fee, where the arrears amount to some hundreds of thousands of pounds, which we are seeing. That court issue fee can be quite hefty. That's £10,000. So before you're even starting to go down this route, you're kind of having to outlay some quite significant sums on top of the arrears. A key issue that is at the forefront of I think everyone's minds at the moment, just because there are some remedies still available, is it actually financially worth going down these roads? Because there's got to be something there. The tenant has to have the cash. There has to be that money there, whether it be an individual or corporate entity. Because otherwise, you might just find yourselves throwing good money after bad.
I think that's got to be right. And if it's any comfort to landlords, I mean, Kate and I were talking about this earlier, we have seen tenants who have been awkward and just trying to take advantage of the position, even though they've been trading throughout the COVID period and making lots of money. Those people are not easy to deal with, obviously. But the reality is there are rather more where the tenants have had a genuine problem, and you can put the tenant to proof and say, okay, tenant, you want some form of holiday or you want the liability to be suspended. Show us what your accounts are, explain to us. And actually, if there's a genuine reason, there's no point trying to get blood out of a stone, is there? If it's a genuine situation, sit down and sort out something temporarily, and it can be documented in a way which protects the landlord's position, and actually is also fair to the tenant.
Yeah, I think that's completely key. I mean, it's something that we have been seeing, because we've been seeing things from all manner of the spectrum, to landlords and tenants working together really well, agreeing alternative structures, rent holidays, etc. Please, word of warning, get that documented to the other end of the scale, where we've got, sometimes landlords, sometimes tenants who will not engage whatsoever. And one of the messages quite early on in the pandemic from the government, and it was around about the time they issued a code of practice, which effectively set out some guidelines for landlords and tenants to follow where a tenant wasn't paying rent. And it essentially just encourages them to talk to each other, and like you said, Andrew, if a tenant can pay, it encourages it to pay. But the difficulty with that, I mean, I think some people thought, oh yes, there's something coming, we've got this code, this is going to help. Unfortunately, the code's got no teeth whatsoever. It's not really worth the paper it's written on, because if parties are going to engage, they're going to engage kind of whether or not the government endorses that or not, in my opinion. And in terms of kind of where this is potentially going and what the government is looking at doing, one of the interesting developments that happened at the start of April this year is that the government has announced or asked everyone for a call for evidence. Essentially, it's almost holding its hands up in the air a little bit, saying, look, we're not quite sure what to do when the 30th of June happens. There's a number of different options, one of which is that's it, 30th of June, all the restrictions end, which Andrew and I were discussing could end up being a bit of a free-for-all then on the 1st of July. I would expect to see a lot of people turning up to work on the 1st and their doors being closed, unfortunately, because the landlord's exercised its right to forfeit the lease. But interestingly, it's talking about potentially a phased winding down of these measures. So where it's actually going to end up, we don't know. It could actually result in the abolition of forfeiture altogether, which is something that's being floated at the moment.
Yeah, it remains to be seen. I mean, who knows what's going to happen between now and the 30th of June and when it will be extended. The only thing I would say on the code of practice, and Kate's absolutely right, there are no teeth there, but equally there's quite a lot of common sense in the code. And it's something we've touched on earlier in this talk. Common sense. There will always be parties who go outside or go to an extreme situation in how they respond. But the code does make sense, and it's something we'd advocate clients follow as a starting point. You might then have to react more strongly if the tenants are being, shall we say, particularly awkward, where they'd have no objective good reason for being awkward. But watch this space, I think, Kate, isn't it, on what's going to happen by the end of June, and in particular on the survey. And I don't think we know yet when there will be a report following the results of the survey having been collected, but it'll be interesting then whether or not that major remedy available to the landlord of forfeiture will either be in some way written out or reduced in terms of its impact. Who knows?
Yeah, I think you're completely right. Just picking up on a couple of points you said there, and one, there is no size fits all. Landlords and tenants, a lot of scenarios are very fact specific, but where a conversation is able to be had, that is certainly something that we would advocate and do actively encourage. And then the second point is, as Andrew said, we don't know where this is going to go. The whole way along, I don't think any of us thought we'd be in this position 1 year down the line. the last extension of the moratorium. So I think when it was extended to the end of March, I can't quite remember, I've lost track. That was called by the government the final extension, and let alone there was another one. You know, it's completely reactive. So I think we just have to wait and see. And then in the meantime, the best message that we can give is, you know, if anyone wants to talk, we're here, and we can give a guiding hand.
Indeed. We've got our finger on the pulse and we're happy to help you.
Exactly. All right then. Well, I think we'll leave it there. I think we've covered everything off. Thank you very much, and thank you all for watching.
Thanks.